if I can share my screen appropriately. And Lisa, just give me the heads up to make sure that things are coming through appropriately. Can you see my screen, Lisa?
Yes.
All right, perfect. So why don't we just walk through a number of different slides. So this is us, obviously, Saul Ewing. Again, it's Bruce and Lisa. We're going to walk through a number of different issues today under the general theme of compliance, including HIPAA, the New Jersey law against discrimination, as well as OSHA, and then some other things that we'll touch upon when we go through the presentation. I will start at the beginning and go through some of the HIPAA issues, and then Lisa will take the lead in dealing with some of the labor and employment issues. By now, all of you who have worked in healthcare should know what HIPAA is about. It's really, really important from the practice's perspective, and behind the scenes, the practice monitors this on a everyday basis, every patient interaction, in terms of making sure that we continue to do the right thing and maintain the importance of patient confidentiality in terms of what we do and how we do things. So from the HIPAA perspective today, we're going to cover a couple of different things. One is to provide sort of a macro overview about HIPAA was all about. There's a couple of different elements to that. There's something called the privacy rule. There's something called the security rule. There's a breach notification rule if something would go sideways and something bad would occur. And then last and probably most importantly is making sure that each of you, whether you're a senior physician, a partner in the group, or a new hire, making sure you understand what your HIPAA responsibilities are in terms of the way you need to do things. So a very basic overview about HIPAA. The law was passed back in 1996. There were some amendments from a federal statutory perspective back in 2009. And the most current iteration of the regulations have been in effect for 8 years now. So this is a federal law. There are also New Jersey state laws as well. But what we're going to be talking about for the purpose of today is only a federal law. Couple of key components for the law from a regulatory standpoint. Again, just a quick reminder: Congress passes a statute. The president at that time, he or she, signs a statute into law, and as part of that process, they inevitably ask the regulators to help interpret what they meant when they passed that statute. So there's a number of different regulations that have been put in place by the Federal Department of Health and Human Services with respect to HIPAA. They include privacy standards, security standards, breach rules, and then, like everything, there are enforcement provisions if somebody does not act accordingly with what they're supposed to do. So at the most basic level, what is the privacy rule? The privacy rule sets national standards to protect the privacy of individuals, what's called protected health information, or PHI. Many of you have probably seen that term before, and it applies to what's called covered entities. So two key takeaways from this slide are protected health information and covered entities. What is PHI? PHI is a very, very broad definition of information. It's anything that identifies an individual, or there's a reasonable basis to believe it could identify an individual. And you'll see at the end of the definition where it's important, no matter how it's maintained, whether we have any paper charts or electronic charts or any other form of medium, any of that information can be considered PHI. So all of the interactions that you have with your patients, no matter how you're recording that information, is likely going to be considered protected health information, and we need to make sure things are handled accordingly. Here's some examples of protected health information. Again, none of this should be a surprise to you in terms of the types of information that you're handling on a daily basis when you're interacting with each of your patients. Key takeaway from this slide: if you're not sure something's PHI, ask the privacy officer. Melody has undertaken that role on behalf of the practice. Dr. Lehrfeld is handling the issues from a security rule standpoint that we'll talk in a little bit. But if you have a question about whether or not something's PHI and how something should be handled, make sure to ask Melody. If you can't get a hold of Melody, make sure to ask one of the physicians, because we don't want to do something wrong when you think you're trying to do the right thing and have a slip up occur with what you're doing. What is health information? So again, we started with protected health information. There's a much broader category in terms of what's considered health information. Apologies, this is a longer type definition that includes a variety of different issues. You can see it basically touches upon everything that you would get involved in. The other important thing to note, for purposes of this definition of health information, it also includes mental health. So to the extent you get exposed to mental health information for any of your clients as part of the intake process or the follow-up process, just know that that information is considered to be health information as well. The privacy rule applies to what they call covered entities. Three types of covered entities. The first is healthcare providers that transmit information in electronic form, which is us. So Jersey Urology Group, we're a covered entity. We need to make sure we're complying with HIPAA. It also applies to health plans, to the Blues, to Aetna, to Medicare. All of those health plans are covered as well. And then there's things called healthcare clearinghouses that are not as directly applicable for us. But just know we, Jersey Urology Group, are a covered entity. We're a healthcare provider. That means that HIPAA applies to us in terms of where the hook is in the statute. Because we are a covered entity, there are certain things we can and can't do with respect to the uses and or disclosures of protected health information. As a general rule, we can't use or disclose PHI of one of our patients unless it's permitted by the HIPAA rules. The caveat to that is there are certain categories that the government has built in where we can share things where we don't need to get an individual's permission to do so, for things like treatment, payment, and healthcare operations. Each of these are defined terms in the regulations and in the statutes as well. So if you need to share information, for instance, with one of the local hospitals, or you need to share information with another healthcare provider, you can share that information for purposes of that patient's care, even if you don't have a specific authorization in place for that individual. So again, general rule is you can't share things unless it's permitted. The exception to that, if you're doing things for purposes of treatment or payment or healthcare operations, you can share that information. So if Carol is looking to make sure that the practice is getting fairly and appropriately reimbursed from one of the third-party payers with which we contract, she has the flexibility to share certain information to get that without making sure that the individual patient knows that we're sharing his or her information. There are certain individual rights under HIPAA, and these are important in terms of making sure you understand this. We'll talk about these in a few minutes as well, but the statute is really governed around the focus of the individual and making sure that the individual, he or she, is in control of what happens to their information and how it's being used and disclosed. So we can talk about each of these different things. Again, these are things that are built in place already that Jersey Urology Group has, but just a reminder for everybody in terms of making sure you understand that individuals have rights. If you're not sure of something, again, with respect to the privacy rule, please make sure to reach out to Melody, and she can reach out to one of the physicians if she has a question, or certainly to me, as from time to time questions come up in terms of how things can be handled. There are a number of other different additional privacy rule administrative requirements. These things are all built in. You'll see that this training element, that third bullet, that's one of the things we're doing now. We make sure to do this on an annual basis so that everyone understands what they have to do. There's a complaint process in place. There are safeguards that we've built in. There are steps that we take if something goes wrong and we want to make sure something's fixed or corrected. Important thing, if somebody raises a concern with respect to a potential HIPAA issue with respect to a patient or a provider, we are not allowed to retaliate against them for raising that issue. I know we would never do that anyway, but just as a reminder that we can't do that. People can't waive their HIPAA rights once they have them. As they're a member of the practice, a patient of the practice, they have certain rights. They can't waive those rights. Number of different policies and procedures that have already been put in place and are in existence for the practice. You all don't necessarily need to worry about those. Dr. Wren and the physicians have access to those policies. Melody has access to those policies. So if there's questions, the goal is to rely upon that policy manual in terms of making sure we continue to do the right thing. Like everything else that you all do on a daily basis, the documentation is the key, and making sure that everything's appropriately documented is important to make sure that the practice is protected in terms of what we do. So that's a very macro overview about the privacy rule. That's one of the different rules that has been in effect for a number of different years, and it sort of governs day in and day out what you do and how you do things. And everybody who's in the practice, all of the physicians, all of the non-physician colleagues, all of the licensed professionals, this applies to everybody in terms of what you do, whether you're working at the front desk or you're one of the physicians doing the procedure, it applies to everybody. The second big rule that I wanted to talk about under the guise of HIPAA is the security rule. While the privacy rule focused on all information, no matter what form it's being used, the security rule focuses on electronic PHI, or electronic protected health information, or what you hear I might refer to as ePHI in terms of how it works. As part of that process, and again, we've built in these safeguards, the practice is appropriately protected, but you should know that there are administrative, physical, and technical safeguards that we need to build in. And Dr. Lehrfeld has taken the point on making sure that the practice remains compliant with the security rule in terms of what we do. So under the security rule standards, it's a little more complicated than the privacy rule standards because there's these administrative safeguards, and you see that I listed, there's 9 different standards they have. There's different ways that these things can be implemented. There's what's called required specifications. There's also things that are called addressable specifications. So the required specifications, as its name suggests, are things that we just have to do. We don't have a choice to do. The addressable specifications are things that can be done a little bit differently depending upon the size of our organization. We are very different than Shore Medical Center in terms of the resources that we might have, the staffing capabilities we might have. So the types of things that we might do to address a particular security rule standard at Jersey Urology Group may be very different than what Shore or Cape does with respect to their hospital resources that they have. In addition to the administrative safeguards, there's also what's called physical safeguards. And then finally, there's also technical safeguards. And again, there are various criterion for each of these. These policies have already been implemented in terms of what we need to do. They're regularly reviewed to make sure if there's any updates, or if Dr. Lehrfeld has a question, he can reach out to me to make sure that everything the practice is doing remains compliant. A couple of key security rule standards that you should just be aware of. And again, these apply to everybody. It's an easy way to trip up and make a mistake and cause the practice some type of an issue. Be careful what you click and what you open. There's a number of hackers who are always trying to send things. I know our law firm gets things regularly, and we always have to be careful about what we open. I imagine you are susceptible to those things as well. Medical practices and hospitals, ransomware attacks happen where people can try and shut down the system by having you click on a link that you shouldn't do. So if you get something that doesn't look familiar, do not open it. Ask Dr. Lehrfeld. He can check with your IT professionals in terms of making sure that it's not some sort of phishing email or something that's going to try and shut down the system. Don't keep electronic PHI on any of your personal devices. The last piece on this slide, be very, very careful for those of you who are working in multiple locations and moving around. An easy way to get tripped up is if somebody breaks into your car and steals a laptop, you lose your iPhone, and there's information on there that should not be disclosed. It's the easiest way to get yourself in trouble in terms of what you need to do. So we just need to be careful about that. So don't take stuff out of the office. Be aware of what you're doing and how you're doing it. Security incidents. These things, when they pop up, these are the things that can give a headache for Dr. Lehrfeld and other folks in the practice in terms of what they're looking to do. It's if somebody tries to get into our system and has an opportunity to do so. As I said a moment ago, healthcare providers are a large target because of where the resources are and the sensitivity of the information that you all hold in terms of where that information can go. If something does go wrong, there is a breach notification rule, which is that third element of the things that we're talking about. Depending upon the scope of the breach and the type of breach, there's different reporting responsibilities that need to occur. We certainly need to let the individual or individuals know who have been impacted. We may need to let the Secretary of Health and Human Services know. And depending upon the scope and timing of the breach, actually the local media maybe need to be made apprised of that as well. This happens on a regular basis. You can pick up any of your local newspapers, to the extent any of us are still reading hard paper newspapers, and see that a health system, for instance, announced that there was a breach. and they're taking all the necessary steps to let people be aware of the precautions that they need to take. Here's the definition of a breach in case you're interested in it. Again, it's a very specific definition in terms of what's being built in to the rule. It's taking things that compromises the security or the privacy of the PHI. There are a couple of exclusions that I include on the bottom of this screen. If something is good faith, unintentional, and it doesn't result in a further disclosure, it may not be considered a breach. If there's an inadvertent disclosure to another authorized person, and it's not further used to disclose, somebody inadvertently sends information from Jersey Urology Group to another one of our practices for the wrong patient, that may not be considered a breach depending upon the analysis. And then finally, there's a catch-all for things that could not reasonably be retained. There's an exception that they built in for that in terms of how it is. An important takeaway with respect to the breach is there's a presumption that something is a breach. So our job, if somebody gets electronic protected health information, it gets into the wrong person's hands or the wrong person accesses that information, one of the things that I would be working on with Dr. Lehrfeld and the physicians in the group is seeing if there's any reasonable way that the presumption can be reversed, meaning that it's not a breach, and we'd have to demonstrate there's what they consider a low probability that the PHI has been compromised based on a risk assessment. And there's several factors in that risk assessment that we would undertake, and we do that regularly for clients because of the flow of information that can regularly happen. Again, Jersey Urology Group is a covered entity, so the burden is on us in terms of making sure that if something does go wrong, that a breach did not actually occur. Here's the notification requirements. As I said before, we always have to make sure that the individual or individuals who are affected know what happens, and we have to do that within a 60-day time frame. So it's a tight time frame. By the time we find out about the breach, we investigate the breach, we determine whether there's a presumption as to whether or not a breach occurred, and making sure that the patient is appropriately notified of those circumstances. The HHS secretary is going to get notice of all of the breaches. It may be on an annual basis, or if there's more than 500 individuals affected, they're going to get notice in a much sooner basis. And then again, the 500 individuals is a threshold that the government has created. If one breach affects more than 500 people, then there's media notifications that need to be made as well. There's penalties on all these different things. The government takes it very seriously in terms of what needs to get done. So just know the penalties can add up significantly if something goes wrong. We don't want Jersey Urology Group to be in that situation, but that's one of the reasons why it's so important that we make sure we continue to do the right thing in terms of how things are working. One of the important elements that the government's been working on, again, as I said before, they have this right of access, that the individuals have the right of access in terms of what they do and how they do it. One of the important things to make sure is that we're doing the right thing by the right people in terms of what we need to provide. So you'll see if an individual requests information, the government's actually created a separate initiative where they can provide this information. We need to turn information around in a timely manner, and we need to give the information to the individuals that they request in a timely and complete manner for what they're looking for. If we don't, the government can investigate, and there's been a number of settlements. There have been 20 settlements to date under this right of access initiative where people, covered entities or health plans have not turned over information where they're supposed to. And the government says you're violating an individual's rights and payments have to be made. So again, as I said a moment ago, there have been 20 of these enforcement actions since they created this a year or two ago. The common themes that have occurred for most of these different things: an individual or a member of the individual's family who has the right to do so request the records. There's a lengthy, sometimes several month delay before responding to that request. And then OCR, which is the Office for Civil Rights within the Department of Health and Human Services, they oversee the HIPAA enforcement activities. They investigate. Sometimes they give a tip to the covered entity in terms of how they can do things. And inevitably, some of these covered entities still don't respond in a timely way. And then the government feels there's no choice, but they need to go and impose some sort of sanction or penalty. I provided here just a couple of different examples of some of these things. You can see that these things can add up pretty quickly in terms of the fines. A practice paid $30,000 because they didn't give somebody timely access to their records. Another practice paid $70,000 for not giving access to their records. So these can be really significant fines. Again, they're very fact specific. Depends on the size of the institution in terms of what they are, but there are real teeth to these things. And that's why we're so concerned about making sure we continually and always do the right thing with respect to giving, one, protecting patients, protected health information, and then two, making sure that folks get regular access to it. Here's some more examples of situations. Again, these are real numbers, and it really has a consequence to Jersey Urology Group if these things happen, because this is coming out of the practice's revenue streams. So we really want to make sure that we're doing the right thing. You can see this something $400,000 settlement from now 4 years ago for inadvertent facts that the employer received sensitive information about the patient that the employer should not have received. You can see the middle one on this screen. Somebody's laptop was stolen, unencrypted information on there. The person who accessed it had access to a number of different files for that provider. Huge fine that they were imposed. So what do you have to do in terms of key takeaways under the HIPAA rule? Protect the PHI. It's really important to make sure that everything you do with every patient that you're seeing, you're maintaining the protection of that individual and the practice's PHI that they're holding. Make sure to follow all of our privacy and security policies, rules, and procedures. If you have a question about it, feel free to ask Melody. You could ask Dr. Lehrfeld or any of the physicians to make sure that you can be helped out. Important takeaway on this slide. If you think there's an issue, please act responsibly and timely and speak with either Melody, Dr. Lehrfeld, Dr. Wren, any of the other physicians who you regularly interact with. This is not something that we can think is just going to go away and hide it and not be concerned about it. These are the sort of things that can give negative headlines to the practice, negative consequences in the community, and break that fundamental trust that all of you work so hard to make sure we have in place between your patients and you as a practice and each of the individual providers in terms of what you do. So if you see an issue, please go up the flagpole and make sure that the appropriate people are notified about what the issue is. We'll leave it at this. Again, there's part of a quiz that will address some of these HIPAA issues that we talked about. It's really important. HIPAA is not going away. If anything, more states are going to impose more provisions in terms of taking more actions to make sure that there are more stringent protections. And the first time something goes sideways is when a state legislature in Trenton or the federal folks in Congress decide they need to make something tougher in terms of what they need to do. So maintain your HIPAA compliance, and I will now turn it over to Lisa, and I will continue to maintain the slides for you, Lisa, but Lisa's going to talk about a number of very important labor and employment issues for the practice. So thank you everybody for paying attention, and Lisa, I will mute myself and let you begin.
Great. Thanks so much, Bruce. And thanks everyone for joining us bright and early this morning. And we know that you all love nothing more than to start your day talking about compliance and all of these fun laws and rules and policies and procedures. And we appreciate you bearing with us, but they are really important. And the practice likes to do this training usually annually so that everybody's on the same page regarding expectations and understanding their rights and responsibilities. So my portion is starting with our anti-discrimination and anti-harassment policies. Obviously, I would hope that you all know that JUG does not tolerate any unlawful harassment or discrimination towards any of its employees in the workplace. And it does this training to remind everyone about its policies, make sure that everyone is informed about the law, and so that you all understand your rights and responsibilities and feel comfortable understanding what the policy and procedure is regarding complaints and just how the policies impact the workplace. Next slide, please. So you probably have seen, hopefully you've seen in the employee handbook, and if you haven't reviewed it recently, you can always go back and check, but the practice has an equal opportunity policy. And what that means is that the practice provides equal opportunities in employment to all employees and applicants, which is not impacted in any way by any protected category We've listed a number of them here, but essentially the practice will make decisions about employment based on skills, qualifications, experience, and not based on these individual traits that are protected by law. It takes that obligation very seriously, and you'll see that policy incorporated throughout the handbook, incorporated throughout the memos. Sometimes the practice will issue kind of supplemental policies to the handbook, which I hope you all are reading and taking into account. But just understand that this is the level that the practice always strives to maintain of just equal opportunity in the workplace. Next slide. So one of the basis for having all these policies and the guideposts that the practice follows is the New Jersey law against discrimination, which is the state law that protects employees from unlawful discrimination at work. It's very similar to a federal law that you may have heard called Title VII of the Civil Rights Act. And essentially what these laws do is they, as I said earlier, protect employees from unlawful treatment in the workplace based on, quote, protected classes. New Jersey law does apply to Jersey Urology Group, as it does to pretty much every employer in the state. And again, this law, it's been in place for quite some time. It's there to protect employees regardless of their level, supervisor, non-supervisor, however long you've been at the practice, it doesn't matter. This is the anti-discrimination law that we most often look to when we think about what standards and policies need to be in the workplace to make sure that everyone feels safe and protected. Next slide. So in New Jersey, as some of you might be aware, New Jersey is actually one of the more progressive states, I would say, throughout the country when it comes to these anti-discrimination laws, which is great. You know, I think more and more states are moving in the direction of having protections for more categories of people, and New Jersey is usually fairly up to speed with expanding the law when necessary. It's still, you know, a developing work in progress, as are many laws, but here's a list of the many protected categories. As you all can see, everybody fits into one or multiple protected categories just based on their identity. These are inherent traits that, you know, they're not decisions that people make, like, what shirt am I going to wear today? You know, what car am I going to drive? What town am I going to live in? These are all, you know, these inherent traits that are just part of you. There are certain things like military service that are also protected, which obviously is a choice, but most things are just something about your nature that is protected. And the practice, of course, will not take any employment actions based on these protected categories. And that includes any supervisors. No coworkers should be, you know, taking any action against any other coworker based on these protected categories. And we'll talk about what that might look like. Just be aware that everybody falls into some category, and the law is pretty broad and protects a lot of different people from a lot of walks of life. Next slide. So we talk a lot, and you might hear, you know, on the news, or you've seen in memos and policies, you know, the term discrimination. What does that actually mean? In terms of employment, discrimination is when you subject an employee to different terms and conditions of employment because of their protected status. So this is not simply a case where, you know, if somebody shows up late to work 5 times in a row and they're written up, that's not discrimination, right? Because you have a time you're supposed to be at work, and if you don't follow that and you get written up, that might be something that happens to you. This would be somebody is not promoted because they're a woman, or somebody is terminated because they're of their race or ethnicity, right? So it's a connection between the employment action and the protected status that makes it unlawful discrimination, and that any sort of conduct that falls in the category of discrimination is strictly prohibited by the practice at all times. Next slide. So we also talk about the term harassment a lot, and these terms often overlap and are intertwined. Under the law, there are some nuances and differences. Basically, discrimination is kind of this larger umbrella term, and harassment is one piece of the umbrella that falls under unlawful discrimination. Discrimination is usually a discrete, like, single act, such as hiring or firing, and some other ones that we're going to go over, whereas harassment is usually a pattern or practice of conduct or behavior that somebody experiences that impacts their employment. And we're going to break those down. Obviously, the takeaway is both of these types of behaviors, when linked to one of those protected categories that we just reviewed, is not permitted and would likely be unlawful and certainly would violate the practice's policies. So we want to avoid any conduct that could even approach that level of prohibited behavior. Next slide. So when we talk, usually this is in terms of discrimination, right? That bigger umbrella term. There's this concept of discrete acts or adverse employment actions. That's kind of legal jargon. But basically, if somebody, as I was saying earlier, is terminated, suspended, they're not promoted, they're not hired, a decision is made regarding their terms or conditions of employment because of that protected characteristic, that would be discrimination. So if somebody is not hired because they have a disability, even though the disability would not have impacted their ability to do the job, that could be discrimination. If there are two people performing the exact same job, exact same skill set, history, experience, and they're paid differently, and there's a pay disparity, and they fall into different categories, that could be discrimination. So these are all the concepts that, unfortunately, you're probably all familiar with. You probably all have heard about these things, just, with all the news coverage that's happened, and just, aware from prior trainings and policies that these things do and can happen, unfortunately, even in this day and age. And the practice goes to great lengths really to consider, its decisions and its policies and how to make employees feel safe, and just making sure that their, decisions are based on employee performance, skills, experience, things that are not related to those protected categories. Next slide. So I mentioned earlier that having a disability is one of those protected categories that, the law protects, that the practice, understands and certainly respects in terms of its policies. So importantly, if any employee has a disability of any kind that impacts their ability to do their job in some way, they should let Melody or Dr. Wren know, so that you can discuss any possible what's called a reasonable accommodation, and determine, what the practice can do to make sure you're able to do your job, as long as it doesn't cause what's called an undue hardship. So, for example, if somebody had a desk position and they couldn't see, they had a small monitor and couldn't see, the print on the screen and needed a larger computer monitor, that could be a reasonable accommodation depending on the condition. Somebody needs a different, desk chair because they have, a lumbar disc issue. You guys are the medical professionals. I'm not, obviously, based on my lingo, but you get the idea, possibly providing a different desk chair could be a consideration. If somebody has, regularly scheduled, doctor's appointments that they need to go to due to a disability, the practice needs to know about that. You have to say something so the practice can be aware of it, take it into consideration, and figure out how we can help you make sure that you're performing your essential job duties, but with any reasonable accommodations that you might be entitled to. So if you have a concern or a question, please say something so that the practice can work with you to figure out the appropriate resources and remedies. We want everyone to feel comfortable and confident that they can do their job. But just, there is a slight caveat here. There are certain health issues that are not disabilities under the law. If you have a temporary issue like a stomach bug, the flu, sometimes even, if you sprain your ankle, things that are temporary and don't usually involve continuous treatment, while the practice, certainly will allow you to take your paid time off, your vacation, you're sick, they'll help you out, as best they can. That's a little different than the kind of chronic or acute conditions that are protected under the law. So that's why it's really important to just, if you have a question, bring it up and we can handle your situation as appropriate. Next slide. Another big topic that unfortunately is still relevant in this day and age is unlawful sexual harassment. Of course, the practice prohibits harassment of any form, including but not limited to sexual harassment. And when we talk about sexual harassment, there's really two categories that you may have heard about. One is called quid pro quo sexual harassment, and that's just a kind of fancy way of saying, if you do something for me in a sexual nature, I'll do something for you. And what that usually means is somebody saying, I will either promote you or not terminate you if you sleep with me, if you do any other sexual thing under the sun, and it impacts some sort of term or condition of employment. And of course, it's unwanted. And it's made.
Oh, is she down here?
Yeah, everyone can just make sure that their phones or laptops are muted. That would be great. Still hearing. It looks like Mike's iPhone. I don't know who that is.
Hi, if folks can get back on mute, that would be great because we're getting some background noise. Thanks, everybody. Please mute your phone.
We get a clip card. This way you don't get.
Okay. All right. Yeah. Please mute yourselves. I'll try to continue. So the other form of unlawful sexual harassment is hostile work environment. That is, I think, usually the more common situation that might occur outside of the kind of Harvey Weinstein's of the world, which is.
I'll give you treats after this.
I'm sorry, whoever's called Mike's iPhone 2020, can you please mute yourself? I think that's where the sound is coming from, and I apologize for highlighting your screen, but I think that's where the noise is coming from.
Yeah, she didn't bring her classes.
Hi, please mute your phone. Please mute your phone if you're not muted. There's a couple folks who are not muted.
Bruce, can you guys mute as controllers of the conference? Somebody may have.
Let me see if I can do that. Todd. I'm not sure if that worked.
Here. I'll do it over there. And then you get some too. And then I got a bathroom.
We're going to keep trying to move forward. If everybody can please mute your phone, that would be great. Thank you.
Okay. Thanks, Bruce. So if you can just go back one slide, actually. Thanks. Okay. So for hostile work environment, that happens when there's these unwelcome sexual advances, requests for sexual favors, or just conduct of a sexual nature that substantially interferes with your ability to do your job. It creates an intimidating, hostile, or offensive work environment. And we'll talk about examples of what that looks like. Just understand, of course, anything that falls under these categories is strictly prohibited. The practice takes very seriously any questions, concerns, complaints regarding this category or any harassment. And of course, any violation of any of the practices, EEO policies, will result in disciplinary action up to and including termination. So in addition to just wanting everyone to feel safe and comfortable, which is the most important thing, anybody who violates these policies is likely to be disciplined or terminated because the practice takes it so seriously. Next slide. So when we talk about sexual harassment, a key term you might hear is unwelcome behavior. And that's really kind of the element that we think of that takes something from maybe consensual conduct to sexual harassment. So when the behavior is unwelcome in the sense that somebody didn't solicit it or invite it, or they consider it undesirable or offensive, that's when we get into the range of harassment. And it of course depends on the situation, the circumstances, what's said, the context, who said it, when, how many times, how it was received. All of that is taken into account, but the takeaway is if the behavior is unwelcome, it shouldn't be happening and it should stop immediately. And even if somebody maybe consented to certain behavior in the past, the second they no longer consent to that behavior and indicate that it should stop or they're not comfortable, it needs to be stopped. So for example, I think a lot of us, we're friends with our coworkers. Maybe we have a group text or email or whatever, where we share, funny texts, memes, TikTok, Instagram, you name it. If that goes down a chain of getting into videos, jokes, recordings of any kind of a sexual nature, and someone says, I'm uncomfortable with this, like, I don't want to see this anymore. First of all, please don't do that with your coworkers anyway, but then it really needs to stop because the person's uncomfortable and it's impacting, possibly their ability to do their job because they're uncomfortable interacting with you and uncomfortable with the content. Same thing for if you're in person and you're telling a funny story that you think is so funny and the punchline is, something sexual. Obviously, we're all adults. We've heard things, and sometimes maybe you mean something and you think it's funny and it's taken a different way. But we need to just be really aware of what we're saying in the workplace to our coworkers, and we don't know how it's going to be perceived. Somebody might hear something and they misheard it and took it the wrong way and it was offensive. You never really know how something is going to be taken or felt. So please just, be really mindful of really cautious and just understand that even though we might have a great relationship with our coworkers and we get to know them, we get close with them, we have to be, maintain that kind of professional boundary. And just be really aware of how our conduct might impact others. Next slide. Okay. Oh, one more. There we go. So another important aspect of the preventing sexual harassment in the workplace is understanding, of course, that victims of sexual harassment can be a victim regardless of their gender identity, regardless of their sexual orientation. So if a woman says something of a sexual nature to me or does something of sexual nature that's unwelcome, that makes me feel intimidated, or that's impacting my terms or conditions of employment, that can still be sexual harassment, even though I am also a woman. Same thing if the individuals involved are both male, heterosexual, homosexual, lesbian, gay. It doesn't matter what your identity is or what your biological sex is. Anybody who is impacted by sexual harassment could be a victim. Also, same thing applies to people who just observe behavior that isn't targeted specifically at them. So if I'm in an office and the people in the room next to me are having a discussion of a sexual nature and they're telling some story that involves something they did on a night out, or there's many things that could come up that could be inappropriate. If I'm continually subjected to hearing these stories or seeing gestures or hearing videos or all these things, and it's impacting my ability to do my job, I could also be a victim, even though I'm not the intended recipient of those messages. So again, just be mindful of where you are and what you're saying and whether it could fall into this gray area that could possibly violate the practices policies. Next slide. Here's some examples of inappropriate conduct or sexual harassment. It could be verbal, nonverbal, or physical. So we've already talked about, sexual jokes, obviously getting out of hand, any sort of imagery, memes, TikTok videos, Facebook posts, things like that. And of course, the most egregious form that we think of is the physical contact, right? So, and that would include, by the way, accidental bumping or rubbing up against someone, anything like that that's unwelcome and that is of a sexual nature could lead to a violation of the practice policies. Next slide.
Like around the holidays.
Again, please, if you're not on mute, please mute your device. Okay, so if you experience or you suspect any harassment in the office, any discrimination, you should know two things. Number one, you have the right to ask someone to stop the behavior that's unwelcome and that's disrupting your work if you feel comfortable doing so. You do not have to approach the person if you're uncomfortable with that, but you have the right to say something. Whether or not you say something, you absolutely have the right to and should report the behavior to Melody or Dr. Wren. Because again, if the management doesn't know about the behavior, they can't take any steps to stop it. So even if it's something that you witnessed that maybe wasn't directed at you, but you have a concern about it or you feel uncomfortable, please say something so that the practice can take the appropriate steps to address it. They really do take these complaints very seriously. They will investigate. They will make sure that there's an appropriate corrective or disciplinary action if one is necessary, but please report. Next slide. So obviously we know based on everything we've said, and hopefully you just know from experience that obviously there's a zero tolerance for any of this prohibited conduct, but you really should report any concerns of potential discrimination or harassment in the workplace. This includes any behavior that you become aware of. This also includes, by the way, if somebody comes to you and says, oh, this person's really bothering me. They keep asking me out on a date and they won't stop. And I've told them no in so many ways. And I just wish they would leave me alone, but they won't stop. Or they keep, making these comments that I find really offensive and I've already talked to them and, or I'm scared to say something, but I just want to vent to you. Like, you don't need to do anything about it. I just want to let you know, like, let's keep this between us. We really want you to still report that because, again, it's not the burden of any one employee to take on this situation and try to prevent things individually. The practice needs to be aware so it can take appropriate measures. And if anybody is in a supervisory capacity, any doctors or anyone else who's in a management position, you have to report that behavior once you become aware of it. So even though we want to respect everyone's confidentiality, certainly the practice is not going to go spreading information around that it doesn't need to, but it needs to be able to have the information available to conduct those investigations and make sure that the workplace is safe for everyone. Next slide, please. So these policies, these anti-harassment discrimination policies apply not only during work hours, but when you're interacting with the public on behalf of the practice, interacting with patients on behalf of the practice, or when you're at practice-related events. So for example, let's say you're on Facebook, if you, or any sort of social media, if you're interacting on a social media account that belongs to the practice, obviously these rules apply. But if you're also speaking in a way that is, on behalf of the practice, or you're speaking to employees about work, we want to make sure that at no time employees are feeling harassed or discriminated, even if it's online. So, there are times where these comments, even if they're on a personal Facebook account or Twitter, if they're harassing or intimidating or threatening towards other employees, and the practice becomes aware of it, that also will be investigated and appropriate action will be taken if that occurs. Next slide. The practice also takes very seriously and prohibits retaliation, another term that probably everyone has heard many times before, but just know that in this context and under the law, illegal retaliation is an action taken to negatively change an employee's terms of employment because that individual did something that's called a quote protected activity. So if somebody raises a complaint and says, I feel harassed, and then that person, the next day is fired, and they're fired because of that complaint, that would be unlawful retaliation. If somebody participates in an investigation and another employee finds out about it and then harasses or intimidates that person because they participate in investigation, that's retaliation, right? So there's a lot of different protected categories under the law, but we don't want to be retaliating against anyone. The practice doesn't permit it. Please know that if you were to ever complain or come forward with any questions or concerns about discrimination or harassment, the practice would not retaliate against you for raising those complaints. Next slide. Okay, we're going to switch gears now. We talked about one kind of aspect of employee safety, which is those kind of interpersonal communications of, preventing harassment or discrimination, which, by the way, not only by employees, but also if there's any issues with patients, vendors, contractors, anybody that you work with who makes you feel uncomfortable, please report it and the policies will apply to those circumstances. Now we're switching gears to OSHA, which talks more about kind of hazards in the workplace and physical, tangible events or circumstances that could happen that could also create an unsafe work environment. So what is OSHA? You can't turn on any news channel this day without hearing about OSHA for any number of reasons, but just so everyone is aware, it's the Occupational Safety and Health Administration. They have a lot of different hats that they wear. They enforce a lot of different rules and regulations. And if you ever have the pleasure of looking at those regulations, your brain will hurt very quickly because they are very dense and difficult to follow, but they're there to protect employees for many different circumstances. And ultimately, OSHA says that, every employer has to have a safe and healthy work environment for its workers. And that's why they have these rules and regulations. And the practice has taken steps to make sure that it's in compliance with OSHA to create a safe workplace, physically for everyone who's in the office. Next slide. So we talked about that OSHA, their main mission is creating a safe work environment for everyone in all different industries and all different positions, including but not limited to the practices that you all work in. And part of that, employees have a right to be at a job site that's free from hazards that are likely to cause death or serious physical harm. Obviously, no one here is working on, like a construction site or some sort of environment where, it's more likely that you're going to run into those circumstances. But of course, when you're in a medical environment dealing with any, samples from patients, any bloodborne pathogens, which we're going to touch on, any equipment that, could injure someone, needles, syringes, anything like that, we have to, of course, take precautions. We have to make sure everything is used in the correct way, disposed of in the correct way, and that, safety is a priority for all of these different components of your workspace. So this is this bloodborne pathogens topic, as I said, here is the most frequently requested and referenced standard impacting medical offices throughout the US. Bloodborne pathogens defined by OSHA are microorganisms that are present in human blood and can cause disease in humans, including hepatitis B and HIV. So obviously, to the extent that any office has any bloodborne pathogens as a result of tests or procedures that are done, we have to handle that contents and material with extreme caution. Next slide. So the practice, to the extent necessary and to the extent that anyone could potentially have exposure to any bloodborne pathogens, has an exposure control plan, which includes, the elements listed on this slide, including proper cleaning and decontamination practices. I think the most important takeaway from this slide is if there's any question about any bodily fluid that you might come in contact with, I don't know if that's water, I don't know if that's something else, judging by the color, I don't know what it is, you all should know that you should treat it as if it is potentially infectious material and take precautions appropriately, not just make any assumptions, and be wearing your gloves and your PPE at all times that is consistent with your position. We want to make sure you're using all your disposable containers and medical devices as directed and as you're trained to do. Of course, if you have any questions or concerns, you can report to any of the physicians that you work with, and they'll make sure that to address any potential hazards or to provide appropriate updates regarding training or handling the specimens or devices as needed. Next slide. So we spoke about PPE here, just again, a reminder, this should be common sense, but I feel like in our line of work, I probably speak for Bruce also, the amount of times that I get a call about something where it's like, if I wrote this in a movie script, no one would believe me that this happened in real life. Like, I can't believe someone actually said and did X, Y, and Z. Happens every day. So it should be common sense, but please don't have any food, drink, cosmetics, anything you're applying to your face or consuming near any potential bloodborne pathogen, any medical equipment, any medical devices, any medications or substances that are used to treat patients in the office, and always engage in the appropriate follow-up after any potential exposure. And that includes making sure that everything is documented if there's an incident, reporting to the physicians that you work with, and of course, contacting any other health authorities as appropriate if there is potential contamination. So in general, you all hopefully should be aware in your respective offices where the exit routes are in case of fire emergency. And ultimately, just know if you see something that looks like it's a hazard in the workplace, maybe, we've had so much crazy weather recently, right? Like if there's something that looks like it was flooded, if there's an electrical issue, if, there's wind damage to anything, obviously, please report to Melody, Dr. Wren, or any other physician. There could be things that happen that others don't observe, they don't realize has occurred. And it's just important to bring these matters to everyone's attention so that, again, we can just make sure the workplace is safe. Next slide. So by now, everyone's probably just, doesn't want to hear the word COVID ever again. I know I would be so much happier if we were past this pandemic. I can't believe that we're still talking about it, but here we are. Please know that the practices policies regarding COVID and maintaining a safe workplace largely are still in effect, and that patients and employees will still be monitored, of course, for any symptoms. We're still going to require masks and PPE. If you're sick and you think you possibly were exposed to anyone, even if you're vaccinated, or you have any symptoms that could potentially be COVID, please stay home and contact the person that you report to talk about the policies and procedures in effect at that time, including how long you should be out due to current CDC guidelines, making sure you're using your PTO appropriately, and all of those related elements to being out. Please don't risk it and come to work. We know you're all very hardworking and very caring about the patients, but having a safe workplace for everyone is really the most important thing. And then just briefly, the slide's fine. Just know, of course, that all of the policies and procedures that the practice follows are still evolving because the government continues to come out with new rules and regulations regularly. So just be on the lookout and be mindful of any new policies or procedures that the practice might issue related to COVID, related to safety protocols, anything of that nature, because it is still an evolving issue even today. Finally, we just want everyone to understand under OSHA what, first of all, there's some resources that you can go to if you had any specific questions about OSHA requirements, but just understand that mainly your obligation is to just kind of, be aware of your surroundings, be aware of any potential hazards or issues, report those hazards, and maintain compliance, of course, with all existing policies and procedures that are in effect. And if you have any questions, speak up, say something. We want to address your questions, and we want to make sure that you understand what your obligations are. And that's all from my end. Bruce, you're still on mute. I don't know if you were speaking. You're on mute. And you're still sharing your screen. Bruce is trying to.
There we go. I
there we
unmuted.
go.
Sorry, I tried to mute everybody in terms of what they needed to do. So thank you, Lisa, very much for walking that through. There is a quiz that we have. If any of you remember Spinal Tap, it's actually 11 questions. So we will make sure that that gets circulated to everybody. Again, if you have questions about anything that I spoke about or Lisa spoke about, please make sure to reach out to Melody or to one of the physicians, and they can make sure to follow up with us. Again, this is part of the importance of the annual compliance review that the practice needs to do to make sure it continues to maintain the highest standards in everything it does. So if you have any questions, let us know. Please make sure to once you get a copy of the quiz, again, it's 11 questions. It's some multiple choice, some true and false. Make sure to fill out your name so we know who took the quiz. It's important for compliance purposes. And if you have questions, reach out to Melody or to one of the physicians. And thank you, everybody, very much for participating first thing in the morning. Lisa, thank you for sharing that information. And hopefully the next time we do this, we'll be able to do this in person post-pandemic as we've done in years past. So have a great day, everybody. And thank you very much.
Thank you all.